Yeah, you had
He
like
said
a
something to me, I
2-year
was like, I can't
probation.
hear you, babe.
Probably, yeah. Laptop's being a dick. Oh, it's because I gotta save this. Hold on.
But as far as the hearing, I got notice of it.
Yeah, I filed it yesterday. It was just to try to recall the KPS. He's here this morning. It's just, at the very least, we're gonna try to recall the KPS. I figured you'd have your own position either way. Yeah, I mean, please, hey, we're good.
Yeah.
He'll sign when he gets out.
Okay. Aren't they all?
Yep.
Of course, I don't have a score sheet for them.
I just wanted to look and make sure you knew your offer discovery was just with Holt or costs.
Yeah, that's right.
You're good.
I'll get the score sheet.
Yay.
And that's just, you and I don't have any other ones.
All during a hurricane. Imagine that.
Like I said, we'll take care of the.
Like you just, there was no real way to like prep for it.
I can announce it all, but it's,
Right, I think I have.
and his brother was possible, I don't know if his brother was gonna be here or not, but I'll leave that up to Rachel. But since it's a grievance.
I'll get Charlie to text her and tell her that we'll just take care of it.
Okay, thanks.
Yeah.
I didn't get the impression she was gonna come up, but I told her that it was, but. Yeah, no, yeah, we can take care of that, that's easy.
Yes, sir.
She reached out. like
Good,
2
how are
days
you?
ago.
Yeah. But I told him first I didn't.
Uh-oh, what?
Get Anthony Miles, the attorney-client. Anthony Miles.
No, I agree.
Well, we met that. We met them both.
You can.
However, the only case on the plea in court.
Yeah. You get used to like, okay, this sentence, this is.
Correct, and then also I can now, okay, now I can do facelift. I can do, fingerprint. I can multitask something up as like right now.
Honestly, this
Yeah.
one doesn't try
I'll send you the written plea.
What I can do is make sure I have all the things that I need,
I don't know how to drive virtual offender.
and then the fees stuff.
Now,
Or like, for the fees for county, I got.
court fees now, there's a back page. No one knows what's going on.
Not even AutoZone.
It was AutoZone. I talked to loss prevention.
They don't know what's
They're
going
saying there's no terminations. And I'm like, well, I have this thing from a law firm, and I can't imagine, especially have coming in, there's no shit.
After he read it.
So I didn't know.
Well, I mean, I think we're getting.
Like, it didn't make sense. How they were wanting to do
I
it.
have my records. You're telling me that you're trying to collect it?
Yeah, and that's,
Good with that?
yeah, that's, I think we're
Yeah, you
good.
don't have a contract. I mean, also, if you sold your debt
Yeah,
for
and
debt,
that was the intent. The intent was
That was my
that.
understanding.
Okay, good.
that's gone. You have zero responsibility to pay a debt collector.
He probably.
Sell a debt like that.
Or they're gonna say,
So we'll see. We'll,
Yeah, yeah.
We'll talk about
Like
it
it
some
was,
more.
and it was like in Alabama.
That is frustrating.
All rise, please. Circuit court is now in session. Your Honorable Judge John Terry is presiding.
Thank you, I see.
Mr. Gilbert. Okay.
Clark Trivet, Judge.
Or Trivet.
Clark Trivet is 24 CF 291. We previously appeared before you, Judge, on August 8th on case 21 CF 2024, and the court, they restored him to probation.
Get that microphone over in front of you. I can't hear anything that you're... Can y'all hear me in the back row back there? Okay. Go ahead.
We're on 24 CF 291 today, and the probation didn't file a affidavit violation of probation. But on this case, we just need to be restored to probation, same as in the 21 case, under the same terms and conditions states agreed.
Your Honor, the intent was originally that the admission would be to both cases. However, I don't believe he's formally admitted on the second case.
Recess.
Phone call, we're waiting.
Okay. Hold that thought.
You're doing a great job.
Thank you. I'll just keep going, right?
We had a couple of minutes on that one.
Yeah.
Yeah. How you doing, sir?
Right.
So it's formally. You see the case numbers they're telling me? I did. Somebody read it.
Take over.
I represent this Shane Long, VOP. Your score sheet here.
I didn't do it. They said the clerk didn't write it down.
Watching the 100 hours completely.
It was fun.
And he
Well,
went
look
over and
who's
talked
up
to her,
there.
and she just mentioned that my original probation, I didn't have no 150.
Why's the clerk?
Oh, really? On the 21
Well,
case?
one of them they sentenced him on, and the other one's got left hanging out there, allegedly.
Yeah, okay, so we did sentence him
What about that?
21.
They didn't do the 24 case. I agree with you. Not none of your problem. So I think
So
what
we're
he's
only dealing with the 24.
24. Anytime he touches anything,
Well, he has the option. And I'll put that on the record.
so we're gonna put in the buyout. Only got Riasti in here too.
He said no.
Why you got one up? Why you got one up?
No, it's a bigger one.
But is yours touch screen?
It's so funny because
How we do it?
I like reach over to talk about something.
Other one too. Yeah, sometimes I'll like. Okay. Hit like Microsoft Edge.
2, 26, 25.
All rise, please. Court's back in session.
Thank you. Sorry about that. Just hurricane-related issues and court schedule from the chief judge and things like that, so. Okay, go ahead, Mr. Powell.
Christine was,
Your Honor, we were here on Mr. Clark Trivet. Originally, as Mr. Powell stated, he had entered an admission on a VOP on case number 21-2024, and was reinstated. The intention was, Your Honor, that he also enter a plea on 24-291. It'll be a reinstatement and 100 hours of community service, and also he has the option to buy those out if he wishes to do so. So we're just asking the court to finish that up today, so he'll have to enter an
You got a
admission.
plea form?
It's just an admission to the VOP, Your Honor.
we admit the violation, and that's what we agreed on, Judge.
All right, is it Trivet?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Powell has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Will, reinstate?
Adjudication, Your Honor, reinstatement with all original terms and conditions plus 100 hours of community service.
All right, reinstate. I'll adjudicate you guilty, reinstate on original terms and conditions with additional 100 hours community service.
And he has the option to buy those out, Judge.
There's no objection, Your Honor.
All right, you can buy them out if you want.
Thank you.
10 an hour?
That's good.
Yeah. Yeah, why not? Yeah.
Is there any
Whatever,
less?
$10 an hour, I guess, is what the going, whatever the legal rate is, the lowest legal rate.
And that's on the 24 case, correct?
Right.
Yes, please.
24,291.
And, Your Honor, he was also ordered to do 100 hours on the 2021 CF 2024. We're not adding that to make 200 hours, correct? It's just
100 total.
100 on both cases, is that correct?
Yeah,
That was the intent, Your Honor.
yeah, all right,
Buy out on both.
yeah,
Thank you, Your Honor.
okay,
That's all I got, Judge. Thanks.
all right. Mr., who is supposed to, Mr. Gilbert? Yeah.
Morning, Your Honor. Michael Gilbert on behalf of Isaiah Clemens in 24 CF 273. He's present, and we've offered a plea.
All right, you're Isaiah Clemens? All right, Mr. Clemens, would you please raise your right hand to be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
All right, you want to enter a no contest plea to the charge, lesser charge of burglary of an unoccupied structure, and also, which is isn't that a third-degree felony?
Occupied structure.
Unoccupied or
It was
occupied?
occupied.
This says unoccupied. Which one is it? Is that a third-degree felony, unoccupied structure? Anyone in the state attorney's office here?
I apologize, Your Honor.
Yes, it's an F3, Your Honor.
It's an F3L4.
All right. So you want to enter a burglary, no contest plea, the lesser offense of burglary of an unoccupied structure, third-degree felony, and criminal mischief under $1,000, a first-degree misdemeanor, correct?
Sir.
Did you read and sign this plea and sentencing agreement form?
Sir.
Are you aware of the rights you're waiving by entering this plea?
Correct.
Anyone force you or threaten you to enter this plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Mr. Gilbert's done for you on your case?
Sir.
Court finds the plea is freely and voluntarily entered. Court accepts it on count one. Withhold adjudication. You're sentenced to 3 years probation. Take anger management class. No contact with Bentley Clemens except as provided for by family or injunction court. Restitution reserved for 90 days. Court costs of $515. And count two. Criminal mischief. What is he sentenced to?
Time served, Your Honor.
Time served. Okay. Sentenced to time served on that. Okay? All right, thank you.
Your Honor, supervision fees wait.
Yes. Do we have a score sheet on this?
May I approach, Your Honor?
Yeah. Next.
Thank you. We'll be out in a minute. Next up is River Harper. She's incarcerated.
Harper?
Yes, Your Honor, this is 23 CF 1883, 2225, and 2601. They're all VOPs. We request a continuance. We've been working with the state closely to do a global solution. There's 7 cases involved.
You have no objection to it.
What about, you want to go October 21st? Excuse me, 31st?
That'll work, Your Honor.
Okay.
Thank you, sir. That's all I have, Your Honor.
All right. Move it up if you, if there is a date, if you get it resolved. Okay, thank you. Is it Tiffany Perns or something like Burns?
Tiffany Pervis.
Pervis? I've got Miss Leah Glisson as, are you defense attorney now?
State, Your Honor, she's pro se. She filed a pro se motion for early termination.
Oh, come on up.
Your Honor, we're here before the court. The defendants filed a letter pro se asking for early termination of her probation in 14 CF 821 and 12 CF 20. In 14 CF 821, she was on probation for 10 years for a DUI manslaughter charge with also a count of DUI property damage. She was given a downward departure for an exchange for a plea to the bench, and she was given leniency based on the victim's family's request. They wrote an impact statement asking for leniency. I do have a member of the victim's family here who drove down from Atlanta to be here today to voice his objection, and I'd be happy to call that victim at this time, or the victim's family, once we put on the record Ms. Purvis's request. I have her letter.
Miss Miss Purvis has been on probation for 10 years?
She's been on probation for 6 out of 10,
Oh, 6
from my
out of 10.
calculations.
Okay.
Approximately 6 out of 10.
Why do you want me to terminate early, Miss Purvis? Let me put you under oath. Would you raise your right hand to be sworn? You swear the testimony you give before this court's true, so help you God?
Yes, sir.
All right, why?
I'll do the rest of it. I just did it because I was told that I could early term. I'll do the rest of it if the court sees fit.
Well, if you got a downward departure, is that correct?
That is correct, Your Honor. She
I'm-
originally scored 11 years. And if I may have Mr. Kinkle briefly come in, since he drove from Atlanta, he would like to be heard.
All right.
Briefly. Joseph Kinkle?
Good afternoon, Your Honor.
Good afternoon.
Well, good morning,
Can
sorry.
you please state your name for the record?
Joseph Kenkel.
And how are you involved in this case?
The victim, Marcus Kenkel, was my son during the accident on January 1st.
And I know you drove a long way to make the statement today. What do you want the court to know
I had written, actually written quite a bit, but I'll do my best to keep it as brief as possible. We did write, mostly at the behest of my wife, wrote that letter for some leniency during the accident. There had been a long relationship between our son and Tiffany, and so there was a bit, during that time there was a bit of shock, and everything was a bit, it seemed like a bit much. For her, in her head, she felt that it was the right thing to do because that's what Marcos would have wanted her to do. Seeing that he had lost his life and Tiffany was, at that point, on the potential of losing a lifetime, because you said 11, the prosecution was shooting for more was shooting for 21 years at the time. And Elena felt that that was just a lot.
And Elena is your,
My wife, yes. That was the right thing then. But there's always been a sense of urgency throughout everything, and then there's always been some sort of grace. And I felt that that act of leniency on my wife was quite an unparalleled act of graciousness considering the circumstances. And then there was leniency with the early departure, the early release, right? And then my wife asked me to come specifically because she didn't feel that everything was quite fair in the great sense of everything, right? It would hurt my wife to know that not only did she not take the opportunities that were presented to her during her incarceration, which was to go get an education, which is something that she and Marcos had talked about, and she had promised to him, and she promised to us that she would follow through with such things, but the urgency instead drove her to just go get work release program and go get a job, and then as soon as she was released, she had a relationship, then she was married, or then she had a child, and all of these things that are rushing, and for us, it feels like there's always one more continual layer to add on to the fact that I'm trying to distance myself from this as far and fast as I possibly can. And so when the request was made, again, it felt like, what is the urgency to rush and to run away from things and just not face them for what they are? And 4 years, 3 to 4 years is a long time to ask again, I want to step away from it. Whether someone advised her or not that that was possible, that's just a self-reflection question on, should I bother to even ask, or should I just look at what I've done and be grateful for the grace that's been granted across all of this time for the last decade? From my wife speaking for her, from the state being gracious enough to grant her early release, and then being able to restart a life of some semblance, right? Because had we not spoken for anything, there was a stronger case on the prosecution side to get 21 years. And so she would have been a lifetime behind. She would have come out 19-year-old, same sort of mindset, similar to Wright. So we don't feel that cutting this off early is the appropriate thing to do in consideration for the crime that was committed, the loss that is still very much present now for us. So we ask, there's times where I will sit at home, even now, sometimes I will sit at home and just imagine the fact that he's going to walk up to the door and just knock on the door and tell us that he's home. The fact that it feels so very real every single day, as I remember walking up to the door and seeing police officers standing at the door with a priest to tell me that our son is dead. All of that is relived every single day. But my son is home, actually, in multiple ways. Home with the Lord, and yet he's home with us as he sits on top of an urn surrounded by angels. And there are times, oftentimes, when my wife would never tell me that I hear her at night asking questions to herself as she cries herself to sleep, even now, a decade later. We don't necessarily want to belabor this. I don't want to belabor this, but the urgency is quite unnecessary. To simply ask for more leniency on top of whatever's been given already, on top of the grace that's been given already. And this isn't a matter of vengeance or a matter of anything. It's just simple reckoning on the side of. And so being released is more of a convenience than it is something that's been genuinely earned. I'll just leave it. I think I can leave it at that.
All right. Thank you, sir.
Sir.
Your Honor, there is no, there's no evidence that her remaining on probation, she's got just under 3 years of her probation to serve. She's not being inconvenienced. She's employed. I think she's just requesting this just because. But I would ask the court to deny the motion with prejudice and ask that she serve the remainder of her probation that is extended. It's supposed to run until September 6th of 2027.
All right, no violations of probation?
She was on probation for a resisting with violence case when she committed this case.
Well, I'm not gonna shorten the probation, okay? So just get it finished and stay away from alcohol.
And if the minute sheets could reflect, that's with prejudice, Your Honor.
Well, I don't know if I can restrict somebody from filing another motion if they want to. For this hearing, it's denied. Thank you. Okay, thank you.
Thank you, sir.
All right, Ryan Hardy.
Good morning, Your Honor. Ryan Hardy with Tim Holt, 23 CF 221. Mr. Holt's here to turn himself in.
All right,
May I ask, did I provide score sheet?
No.
No, may I?
yeah.
You didn't do.
I don't think I sentenced him, did I?
You did, Your Honor. We just didn't
Did I
have a score sheet.
adjudicated guilty and sentenced him, what was it, 3 years minimum mandatory?
Yes, Your Honor.
Credit for time served, concurrent on both counts or something?
Yes, Your Honor.
May I approve?
You know what you were facing.
Yes, sir.
What I suggest you get your time done and stay away from these drugs. Okay?
Thank you, sir.
All right, thank you.
Stand right here for me, sir.
Mike Flowers.
Good morning. Here, Herbert.
Herbert.
Your Honor, she is present. Yeah.
Geral Herbert, 23 CF 1676.
Yes, sir, Your Honor. At this time, Ms. Herbert has executed, and the state's executing now, pretrial intervention agreement, I think.
All right.
The plea agreement first?
Yes.
May I sign it?
Yeah. All right, the plea is as follows. She's hearing a plea as charged in the case number that the court announced, and the plea is to, or consistent with, the pretrial intervention agreement that contemplates a one-year probationary sentence with the terms which are contained in the pretrial intervention agreement, and that's what we're here to do this morning, Your Honor.
Are we sentencing this morning or deferring
No,
sentence?
we're deferring, Your Honor,
Okay.
based on the pretrial intervention agreement.
All right. Ms. Herbert, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God.
Yes, I do.
You want to enter into this agreement with the state attorney's office, that if you do what the agreement says, then the charges will be dropped? Okay. Has anyone forced you or threatened you to enter this agreement?
No.
Thank you.
Are you aware of the rights you're waiving by entering this agreement? You know, your right to go to trial and have a jury trial and be represented by an attorney and all that. You're waiving those rights and other rights. You understand that? Okay. Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Flowers has done for you on your case?
Very.
Okay. All right, well, just complete the agreement. Yeah, and I believe, I haven't seen it, but typically the charges will be dropped. You got 1 year.
Judge, I provided the agreement to Mr. Berry, and that is what the agreement reflects.
All right.
Would you like a copy of that agreement with?
I think the probate, you got a okay.
He has it.
All right, well, just do what you're part of the deal, and then the charge will be dropped, okay? All right, thank you.
Thank you.
Do you want to call your case?
Good morning, Your Honor. Matt Gordon for the state. Tristan Parker.
And Your Honor, Mr. Parker is listed on the docket under my partner Tim Shaw's name.
Yeah.
Judge, may we approach briefly before I make an announcement, myself and counsel?
Yeah.
Você cria cor, traz a paz das estrelas, meu amor. Quero te ver brilhar, quero te ver sonhar, como a luz do sol.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Discussions with Mr. Gordon. There are a few other very minor things that I need to clear up. Judge, this will be a plea. We're asking that this matter be set, and as we just discussed with the court, the earliest possible opportunity is October 31st. We'd like for the court to set this matter for a plea on that date. I'm aware of the amount of time. I'm also aware of the discovery that due diligence had to be done, and we've done due diligence with the full cooperation with the Office of the State Attorney. We're announcing or asking the court to set this matter for a plea on October 31st.
All right. Any objection to that?
No, Your Honor.
All right, October 31st.
Thank you, Your Honor.
Thank you. What y'all want, in the morning or afternoon?
I prefer morning.
Morning's fine, Your Honor.
Morning. Okay, thank you.
Thank you, Your Honor.
Judge, I had one other matter.
Yeah.
Before the court, Chase Brunson. And Mr. Brunson, we reached a plea agreement, which he in fact has signed, but I believe that he has been, and I apologize for this fact, he's been called out for hurricane duties, and I think that he was confused about the days. And I would ask the court to give me an opportunity to reach him and not take any action for his failure to be here. He's been in constant contact with my office as recently as yesterday.
All right, so he's going to enter a plea, you said?
Yes, sir, and it's a probationary plea.
Well, we can put him, you want to do him on October 28th?
That'll be fine.
Without objection.
That's pretrial conference day.
Yes, sir. That'll be fine, Judge.
All
I
right.
appreciate that.
Okay.
And Judge, that's all I have before you this
All right,
morning.
thank you.
Thank you, sir.
Any other private attorneys I don't see? Okay, Mr. Gibbs, or,
Your Honor, I do have a few out of custody, if I may.
okay.
While we're waiting on that. Oh, that's fine too, if the court would like to take pro ses.
Let's take some pro ses.
Very well, Judge, thank you.
So the first one I see is Bell Carr, Aslan Bell Carr.
Mayor. So she, if I'm not mistaken, I believe your assistant got an email as well, that she's incarcerated in Miami-Dade County. And I responded to Mrs. Gary that I didn't have an objection to continuing the case and not issuing a capias.
All right.
I'm showing as appointed on Ms. Bell's case as well, Your Honor. I spoke with Mr. Sprouse about the same, and I would request a continuance to a later date so we can confirm where she's at.
All right, what about October 28th?
No objection. That's fine, Judge, for pre-trial.
Okay.
Thank you.
All right.
Aurora Bouchard.
Aurora Bouchard, pro se. Haven't I heard that name before, Aurora Bouchard?
We set her for, today, Judge, for, essentially, I'm going to dismiss the case.
All processing it?
She does have some outstanding court costs, but the reason she was coming back was for the recommendation of treatment, but there is no recommendation.
All right, well, just file an all process on it. She got court costs?
She has court costs. So.
I don't know how she can have court costs if charges are dropped.
That's correct. I think if we should kick it for the next date.
No, just drop the charges if that's what you're gonna do. Okay. All right, thank you. Next,
Jonathan Ezra.
Your Honor, for the record, on Mrs. Bell Carr that the court said earlier, in fact, I am not representing her. She is pro se. I was confusing that with an Azaria Bell in a different case, who I do represent, that we believe is in a different county right now.
oh, so Miss,
So I'm not appointed to Miss Bell Carr that our bailiff.
is this, what is Miss Belcar supposed to be here for?
She, I believe, is a VOP, is that correct?
Yes, sir, Your Honor, she had a VOP, and since she's been out on bond, this is Bell Carr, correct? She has picked up another charge of battery domestic violence.
No bond, capious.
I thought she was the one in Miami.
She's supposed to be the one in Miami.
She's the one in Miami that we put on the 28th.
She is?
Yes.
I thought you just said that you made a mistake and it wasn't that person.
Your Honor, the mistake that I was making, the case number for Ms. Bell Carr is 21 CF 1354. I was confusing that with Azaria Bell, which is 24 CF 2027. She is set for the arraignment, or was set for the arraignment docket this afternoon.
All right, so Miss Belcar's in jail or somewhere in Miami?
That's our understanding.
All right, well, we don't need to do a capious for her.
Thank you, Judge. Sorry for the confusion.
Your Honor, I'm not saying she's in jail.
You're not?
I'm not.
Well,
I
who said she's in jail?
I said she got arrested for a new charge of battery domestic violence down there. I have.
All right, no bond, capious. No bond, capious, then.
So.
Oh.
I don't think we need to do that because I'm in agreement for not doing FTA. She's incarcerated per the public defender down in Miami. The public defender down in Miami emailed Ms. Gary, your judicial assistant.
So y'all don't want a capious?
Correct.
All right, no, we'll withdraw that capious then.
Thank you, Judge.
Sorry for the confusion. This is Mr. Ezra.
Judge, Mr. Ezra's before the court on a motion to modify contact with minors. He was here last month and the state cited Florida statute 94830 and he was sent to Mr. Josh Kelly at probation. However, Officer Kelly has advised that what he's seeking, which is to have a number of minors live in his home with me, would be considered unsupervised contact. Florida statute 94830 only grants supervised contact when certain conditions are met. We provided a copy of that statute to the defendant's wife via email earlier this week. My read of the statute is that you cannot have unsupervised contact with minors while on sex offender probation, because obviously with overnight stays, which is what he's seeking, there's the potential for contact per probation. 94830 outlines a number of requirements, and the defendant has provided some of those pieces of paperwork to the state, but again, that's for supervised contact with minors. We would note that the risk assessment doesn't necessarily have all the requirements, and there still has been no safety plan. And while not controlling in State v. Walk, 267 Southern 3rd 438, trial court erred in removing mandatory probation condition, prohibiting the defendant from having unsupervised contact with children under 18 following conviction for possession of pornography, where court did not first consider the statutorily required prerequisites for allowing even supervised contact. So at this point, because he can't even meet the criteria for supervised contact with minors, We would object to contact with minors that is unsupervised. In walk, they further stated that while 948.032 generally allows a trial court to rescind or modify terms of conditions of probation at any time, the trial court was not authorized to remove a mandatory condition of probation. And they cite State v. Spring. I do have a copy of the statute in the case for the court.
I mean, right now you have supervised visitation, is that what you have?
Yes, sir. Yes, Your Honor.
And you want unsupervised?
The unsupervised portion is just so I can live with my family in the same house.
Is there certain things he's supposed to do, to get this unsupervised, he still hadn't done yet? Is that what you're saying?
Your Honor, I've completed the treatment program, and I have the risk assessment that states, their professional opinion that it would be okay.
You provided that to
And the
Mr. Barrett?
written letters from my stepchildren's mother and the grandchild of my biological child.
Judge, some paperwork was provided to the state this morning. However, it doesn't have everything as required for the risk assessment plan. There is no safety plan. And most importantly, that's for supervised contact.
Right now he has no contact?
Any unsupervised contact with minors while on sex offender probation.
He has no contact or supervised?
He has supervised contact with minors.
Right now, he's got
He
supervised?
already has supervised, but in walk, they considered whether or not he would meet the recommendations of supervised for those minor children specifically before granting any sort of other supervision. Probation. May I approach with this copy of the statute?
Well, so you're saying that under that law, I cannot grant unsupervised probation?
There are no provisions for granting unsupervised contact with minors under 948.30.
Well, I gotta follow the law. That's what it is. I can't grant unsupervised contact while you're on probation with this offense. So, denied. Sorry.
Yes, sir.
Thank you. Next case.
Billy Grace.
Grace.
He's on there under Billy Grace and then Billy Grace Jr.
All right. And this is 23 CF 1048 and 22 CF 304. Okay. Yes, sir.
Yes, sir.
This is a request for, what are you here for?
Completion of probation.
Any has he completed it? Any objection, state? You want an early termination, is that what it is?
No, I completed a full term of probation. In fact, I paid the last bit of my court costs before I come to court this morning, and I have the receipt for it right now.
Okay. Mr. Berry, is there some reason his probation can't be terminated?
We showed a balance of 158.08. Your Honor, he had two case numbers.
Yeah.
The one he brought me shows a zero balance in case 2022 CL 304.
Yeah.
But he also has another case of 23 CL 48.
Okay.
If the clerk wants to check and see if he has a balance on that.
All right, she's checking. He says, all right, he says he's paid in both cases, so you're good. All right, you're good. Probation's finished.
Thank you.
Okay.
Probation terminated?
Yeah, probation terminated. All right, thank you, sir.
Thank you.
Good.
Cassandra Novinsky.
We got Cassandra Novinsky. All right, what did you want? What's your petition? Are you filing did you ask for your probation to be shortened or terminated?
I was required to finish my last Patterson treatment. My case was continued because I had already had the treatment paid for and everything. It's just I was a little bit late when the appointment was set, but I've finished all my requirements.
Has she provided the documentation to probation?
You provide the documentation to probation?
Yes, I did.
Mr. Barry? Mr. Ken? You got to turn that stuff off over there.
Something beeping.
Your Honor, what she's done, she's completed the treatment program. However, she still owes some court costs. We request the court costs go to collections and be terminated.
All right, terminated and court cost to collections, okay?
Thank you, Your Honor.
All right, thank you.
One pro se in custody, but I don't know what else do you have.
What do you got?
I have an inmate in custody, Your Honor.
Who is it?
Shane Long.
Shane Long, you want to enter a plea or something?
He does.
Okay.
It'd be just a second for him to come out. If we can handle the pro se real quick, then we'll have yours on. Mr. Batson. Is it Neil Batson? Pro se. Like your nephew,
All right, Mr. Batson.
Yes, sir.
Let's see.
Judge, I have Mr. Batson in 23 CF 2350 for a BOP. Apparently, there was a new law violation. If my memory serves me correctly, in Walton County. It was already pled to it. So the offer currently in Mr. Batson's case is an admission, 45 days Okaloosa County Jail, and $100 cost of prosecution.
Any credit for time served?
It's not credit for time served, it's 45 days. He's gonna have like a few more weeks.
Mr. Batson doesn't have an attorney. Would you like an attorney, or you want to accept that?
I just accept that.
Okay. Would you please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God?
Yes, sir.
I don't see Mr. Batson on my docket to see.
Can I not get credit for time served?
It's 45 days.
Oh, I got him.
Yeah, but credit for time served the first time?
He's gonna get credit for his time served. He's entitled to that.
Okay, I was going to say, all right. You want to admit that you violated probation?
Yes, sir.
You can put your hand down. Did I swear you in? Would you raise your right hand? You swear the testimony you give for his court's true, so help you God?
Yes, sir, I do.
Okay, thank you. You can put your hand. So you want to admit that you violated probation?
Yes, sir, I violated probation.
Has anyone forced you or threatened you to make this admission?
No, sir.
Are you aware of the rights you're waiving by entering this admission, especially your right to an attorney and advice by attorney?
Yes, sir.
Are you under the influence of medication or drugs that prevent you from knowing what you're doing here today?
I'm not under the influence, and yes, sir, I know what I'm doing.
Okay. Court finds admission freely and voluntarily entered. Court accepts it, sentences you to 45 days Okaloosa County Jail. Credit for time served, and was a $100 cost,
That's correct, and we'll terminate his probation.
and terminate your probation. $100 cost.
And
I'll get, huh?
I'll have a score sheet for you.
Okay, and I give you 90 days to pay it, and it goes to judgment.
All right, thanks, sir.
Pardon? Yeah, concurrent. Okay,
Okay, thank you.
thank you. All right, Mr. Riasti.
Morning, Your Honor.
Morning.
Joseph
Shane.
Riasti for Shane Geral Long, who's present.
Okay.
Shane Darrell Long, who's present before the court in 2023
CF 2818 and 2024 CF 668, which are both violations of, felony violations of probation. At this time, Mr. Long has agreed to admit the violations with the understanding that he'd be sentenced to 18 months in the Department of Corrections with credit for all time served. And this is a negotiated plea with the state.
Is that both cases concurrent?
Yes, Judge.
All right, let me have it. You got a
I
form?
have a score sheet, Your Honor, if I might approach. This is he scores 25 months. Scores 25 months.
All right, Mr. Long,
Yes,
would you
Your
please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God.
Yes, Your Honor.
You want to admit you violated probation in 23 CF 2818 and 24 CF 668?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this admission? You
Yes, Your Honor.
your right to have a trial before me, a right to remain silent.
Yes, Your
and, okay. You, anyone force you or threaten you to enter this admission?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Be happy with the work your attorney, Mr. Riosti or Ms. Flowers, has done for you?
Yes, Your Honor.
Court finds the admission freely and voluntarily entered. Court accepts it. Sends you 18 months. Department of Corrections concurrent on both cases. Credit for time served. Okay? Yeah.
Revoke and terminate.
Yeah, revoke and terminate probation. So when you get out, you don't have any probation. Go on down there and get off these drugs now, okay? All right,
That's all I have before you.
okay.
Let's go ahead and line up. I know there's quite a few out. Your Honor, I have
Timothy-
a few out of custody, if I may.
All right.
Your Honor, the first person I'd like to call is Mr. Nicholas Adkins.
Atkins.
Your Honor, Mr. Adkins is present and approaching. Judge, we're here for 24 CF 1457. Judge, we're going to request a continuance to October 28th. We are working with Ms. Balancier, who is the mental health forensic coordinator here for Okaloosa County now that Mr. Barnes has retired. We're working on getting Mr. Adkins on the conditional release, or adding this case to the conditional release he's already on.
Okay,
That's without objection.
all right. October 28th. Let's give Mr. Atkins been to court many, many times trying to,
Now
Yeah.
that we have Ms. Balancier in
yeah,
place.
he
we'll be
keeps
able to-
coming to court and they all keep, he's doing what he's supposed to do. I mean, he's almost served as much time in court as I'd give him in jail. I mean, just, all right,
Thank you, Judge.
October 28th.
Your Honor, next out of custody, I have Ms. Courtney Ard. Seeking the response, Judge.
Courtney Ard.
Courtney Ard, Judge.
She's here for just,
It was a status conference, Judge. We were hoping to try to get the case resolved.
she haven't heard, she's not here.
She's not here that I can see.
You can't tell me whether she's here or not, right?
I can't tell you that I see her.
Okay, no bond, Capias.
Understood. Next out of custody, Judge, I have, skip over all of that, Ms. Melinda Carroll.
Geral.
Your Honor, Ms. Carroll is present and approaching. I met with Ms. Carroll earlier this week, looking at the allegations and the facts that we have now. We're going to ask to continue this to October 28th. We have some subpoenas that we want to send out to get some records before we try to get this one prepped.
Okay, October 28th, Ms. Carroll. Thank you.
Thank you, Judge. All right, give me a call. Next out of custody, Judge, I have, for the morning docket, I have Zacchaeus Guerin. Zacchaeus Guerin? Judge, he did send me an email asking if court was open today. I didn't see that until after closing time yesterday, so I did not respond to him. I don't see him this morning, but I do have contact with him otherwise.
His name is Carroll.
I'd asked to just put him on 1028. We were working on getting a PTI set up for him, but we found out more information that
Not looking good for Mr. Garin.
Not.
So,
Garrett?
Garin, Garron.
Oh, Garin.
33 on mine, sir.
All right, we'll set him for October 28th.
Thank you, Judge. I appreciate it. And then next out of custody, Judge, I have Tricia Gatewood. Your Honor, Ms. Gatewood is present and approaching. We have been in negotiations with the state about different offers. I do want to request a continuance. We are requesting transcripts of our depositions that we've taken of the children to be able to discuss with the state of any potential additional negotiations or even potentially having to set it for trial if negotiations fall through.
October 28th.
Thank you, Judge. All right, give me a call. Next out of custody, Judge, I have Mr. Dennis Gibson. Your Honor, Mr. Gibson is present and approaching. We had set this for a status. He had a new offer. At this time, he'll respectfully decline. We'll ask to set this for pretrial conference 1028.
October 28th. Thank you. Thank you, sir.
Thank you. And last out of custody, Judge, I have Mr. James Green. Your Honor, Mr. Green is present and approaching 24 CF 1441. Mr. Green was added late yesterday afternoon to recall his capias. We would request that his capias be recalled. He also has a resolution, if I may approach.
I don't think I have him on the docket.
It was a very brand-new addition, but I do have it.
And I'll have a score sheet to Your Honor after court.
All right, you're James Green?
Yes, sir.
Okay, this is 24 CF 1441. Mr. Green, would you please raise your right hand to be sworn? You swear the testimony you give before this court's truth, so help you God?
Yes, sir.
Okay. You want to enter a no contest plea to the charge of carrying concealed firearm, third-degree felony, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication withheld, $100 cost prosecution, $415 court costs, $150 PD fee, due within 180 days or sent to collections and reduced to judgment.
Thank you, Judge.
Okay? All right, thank you.
That's all I have, I believe, out of custody at this time.
Yeah, I'll recall the capias.
Thank you, Judge. That's all I have at the moment.
Judge, I've got some that I can call. Judge, if I can, let me call, he's not on the docket, but Jason Howell had previously failed to appear. I can't recall if it was for docket day or if it was for his pretrial conference. He has contacted our office, and he's in court today. I'm going to ask the court to instruct him regarding his next court date, let him explain why he missed court, and ask the court to withdraw the capias if the court would consider that today.
Jason Howell?
Howell, Howell. Is that correct, sir?
All right, why were you not in court?
It was Labor Day weekend. I just started a new job the Friday before, and I had the court dates confused. It was scheduled for the 3rd, which is a Tuesday, which the last 15 months I've been coming up here, all of our court dates have been on Monday. And just between starting a new job and I knew I had court Monday, well, I did come up here and, you know.
You've been in jail, didn't I let you out on bond or something, or?
No, sir.
No? All right, I'll withdraw the capias.
Thank you, sir.
Thank you, Judge.
Give him
And
October, what about October 28th?
that's fine, Judge. That would put him back on the cycle.
Okay, October 28th.
Thank you, sir.
Get with your attorney, see if you can get your case resolved, okay?
Yes, sir.
Thank you.
All right, Judge, also, we've got an Anthony Hawkins. He's in the state hospital, was not transported over. The state hospital sent documentation that he's now competent. I've got, the court, I think, signed an order to transport, but he has not been transported. I've got a stack of orders that the court can, paper orders that the court can sign and put in the court date that the court wants him back in, if I can approach.
All right. Probably the hurricane, they didn't transport him or something, I guess.
That's what I'm guessing, Judge. And if you'll just let me know when the court.
Why don't we do Why don't we do October 28th?
No objection, Judge.
That's fine, Judge. Judge, the next case that I've got is Michael Johnson. Mr. Johnson? Judge, Mr. Johnson doesn't answer.
Judge, we're going to ask for a capias. This is an old case.
Wait, this says the defendant shall not remain at the facility pending the above scheduled hearing.
The idea, Judge, is for him to be in the jail so that we can continue to work on his case and get his case resolved. We actually have an offer on the table for time served, so I anticipate once we can get him back to our jail, we'll be able to resolve the case. That's the draft order that the facility provided with their paperwork, Judge.
We just make sure that he stays incarcerated until the case is resolved.
This sentence could be read to that he be released from the.
Judge, you want me to
Just look at this. I'm not going to sign.
retype that and change it to Florida State Hospital or something of that nature?
Just look at that and tell me, I can scratch it out, write whatever I want on there, but
Appropriate detention. I'll grant you, it is, it's at the very least vague because they use the phrase facility to refer to the paragraph above.
it looks like I'm ordering him to be transported, but not remain at the facility, and, you know,
What-
I don't know.
What I would suggest is perhaps,
Y'all, what I suggest is y'all get together and give me an order that keeps him in the facility or in the jail until we have this hearing.
my secretary has one that we use.
All right.
And I'll just tell her to do it.
Yeah. I didn't sign that, did I?
I don't believe so, Judge. I don't think you, no, you did not.
Okay. All right, next.
Kenneth Martin.
What are we doing with Michael Johnson that didn't show?
Oh, Michael Johnson did not answer the call for the court, Judge.
No bond, capias.
Thank you, Judge.
This is Mr. who?
This is Mr. Martin, Kenneth Martin.
Malone.
All right, Judge.
Kenneth Martin, okay.
Yeah, this is going to wind up being a plea, Judge. We've been
Today?
exchanging draft.
See today?
Excuse me?
Today?
Today, yes, sir. There you go. Let me get your signature right there. It's for a withheld 3 years probation, anger management class, parenting class, and costs and fees.
Mr. Williams, do you have the score sheet to go with that?
I don't believe I do. If I do, it won't be properly marked up.
Mr. Martin, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
Okay.
He scores less than 44, so not a downward departure.
Mr. Martin, you want to enter a no contest plea to child abuse without great bodily harm, a third-degree felony?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Adjudication withheld. 3 years probation. Take anger management class, parenting class, standard costs, cost of prosecutions, PD fees, and cost of supervision waived. Okay?
Yes, sir.
All right.
Thank you, Judge. You're going to need to talk with, do you need him, it's a withheld, so I don't guess you need him printed, do you? Go ahead and have a seat right over there. They're going to talk to you for just a minute. Judge, the next one I have is Cindy Mullins.
Cindy
And Judge, this one is going to be a plea to pretrial intervention.
23 CF 2189. Ms. Mullins, please raise your right hand to be sworn. You swear the testimony you give before this court is true, so help you God.
Sir.
Okay.
Signature right there. Oh, today's the 26th. Does the court need a copy of the PTI agreement to read off the terms and conditions, or are we
No.
just going to? Okay.
Well, she got a year to do it?
Yes, sir, I believe so.
That is correct.
All right, Ms. Mullins, you want to enter into this pretrial intervention agreement with the state, correct?
Sir.
And you've read over the terms of the agreement?
Yes, sir.
Has anyone forced you or threatened you to enter this agreement? Are you under the influence of any medication or drug to prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work your attorney, Mr. Williams, did for you?
Sir.
If you complete the agreement, then the charge will be dropped. You understand that? If she doesn't complete it, is she to be sentenced according to this agreement?
Well, yes, sir. Yeah, basically, it's an open plea to the court at that point, and the court would be able to do whatever the court felt like was appropriate.
All right. Well, you got a year to do this agreement, so let's get it done. And okay.
Thank you very much, Judge.
Judge, I think that was all of the custody that I had. Mr. Harsher there is covering for Mr. Henderson.
All right.
Anthony Miles.
Miles. Morning.
Your Honor, Dustin Harsher on behalf of Anthony Miles. This is case number 2019 CF 3289. I'm aware that the state has filed a traverse on the motion to dismiss that was scheduled for a hearing today. The only thing that I would put two things on the record for that, Judge, and that's just I'd object and move to strike the state's traverse based on timeliness, as well as looking at the state's traverse in the short time that I've had my hands on it. I still think when you look at the facts that are put in dispute, the additional facts that are alleged to be available to dispute any kind of factual allegations that are made in the motion, still don't establish a prima facie case for harassment of the alleged victim in this case, Your Honor.
All right. Well, what does the state say on that?
Your Honor, as the defense has already stated, the state did file a traverse and demurrer. We do allege that the material facts do establish a prima facie case. However, there are material facts that are in dispute, and if they are in dispute, then the court must deny the motion to dismiss, and that is our position.
Have y'all taken depositions on this?
Well, that was my other thing I wanted to put on the record, Your Honor, is there are some allegations of some other witnesses, some vague references to witnesses' depositions, just testimony. If there are additional witnesses that can dispute these factual allegations, then either myself or Mr. Henderson needs to be able to take their deposition, so I need to know who those people are.
Your Honor, the witness list has been provided, but we certainly can re-engage on that.
Well, I think the law is pretty clear. If they file a traverse, then it's
I
got to be
understand, Your
denied, but still subject to motions, various other motions to suppress and dismissal or whatever, if you get these other witnesses and you get their deposed. But, you say there's material dispute, that there's no dispute as material facts, and that does not lay the basis for a prima facie case, and the state says, yes, there is a dispute as to material, then I've got to.
I understand.
Everyone would just file that motion, and Judge, there's nothing here, you're right, dismiss, I mean, they have, all they have to do is say traverse, and it's,
That's my understanding. Your Honor.
okay, all right, thank you.
The only other thing is the state mentioned that there's been a witness list provided. I've not seen that witness list. I reviewed the record this morning. There was 2 discovery exhibits that have been filed. One is a birth certificate. The other are some Category A witnesses. I'm just not sure.
Well, just
who's-
check into that, Ms. Basso, and see.
Your Honor, this
maybe-
case was combined with the human trafficking case, so everything applies to both cases,
Oh, okay, well, all
which
right.
they also handled.
All right, well, maybe we'll have some other kind of hearing in the future, I don't know, but,
Sounds like it, Judge.
okay, thank you.
Thank you, Your Honor.
All right.
I was also going to cover a case for Chris Crawford. I believe the client's name is Isaiah Drawsand.
And may we approach real fast, Judge?
Yeah.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is
some
just
hurricane
one block
issue,
south
him
of the
getting up
courthouse
here.
in historic downtown Crestview.
So we'll continue him till October 28th.
Thank
Okay?
you, Judge.
And that's supposed to be a plea, right?
It's going to be a plea, yes.
Okay.
That's my understanding, Your Honor.
All right.
And on Mr. Miles, Your Honor, was that continued to a new date?
Yeah, say
Apologize.
October 28th, pretrial conference.
Thank you, Your Honor. I believe that's all I have. Good to see you.
Thank you.
First will be Samuel Allen.
Mayor Jim Gibbs on behalf of Mr. Samuel Allen. Judge, this is case number 23 CF 1080. I believe we have an agreement. We're going to review the written plea real quick so he can
All
sign.
right.
If I may approach, Your Honor.
This is 23 CF 1080, State of Florida versus Samuel Allen. Mr. Allen, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Sir.
All right, you want to admit that you violated probation?
Yes. Yes, sir.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this admission?
Yes, sir.
Are you under the influence of medication or drugs to prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Mr. Gibbs did for you on your case?
Sir.
Court finds the admission freely and voluntarily entered. Court accepts it, will revoke and terminate probation, sentence you to 30 days Okaloosa County Jail, credit for time served, $100 cost prosecution, $150 PD fee due within 180 days or to a judgment.
Sir.
And adjudicated guilty. Thank you.
Good luck.
All right, thank you.
Go over, Nick.
Your Honor, Tim Gibbs on behalf of Mr. Christopher Arnett.
Okay.
Your Honor, Tim Gibbs on behalf of Mr. Christopher Arnett. Judge, we've been working on trying to get Mr. Arnett into drug court, but he has a Holmes County hold that's preventing him from getting in. We're seeing what we can do about that. I'd like to continue his case to October 28th.
All right. October 28th. Thank you, sir.
Thank you, Judge. Yeah, that way we can try to get it in.
Thanks.
Your Honor, Tim Gibbs on behalf of Mr. James Banks. Judge, this is 23 CF 1081, 23 CF 1083, and 23 CF 1554. Judge, we're going to ask for a continuance to October 28th on this one as well. He is also in mental health court on 3 VOP cases where he is expected to be sentenced in the next couple weeks. So we're going to ask to continue for that.
October 28th. Maybe we can
Thank you,
clear it
Judge.
up. Thank you.
And then I'll get in touch with Mr. Russell as well. Your Honor, Tim Gibbs on behalf of Mr. Nicholas Bennett. Judge, this is 24 CF 1111, 24 CF 1112, and 22 CF 1884. Judge, I believe we have an agreement that should be getting signed momentarily. For Phoenix House. Let me make sure.
Is he entering a plea?
I'm sorry, Your Honor?
Is he entering a plea?
Yes, Your Honor. He's entering a plea. We're getting the written plea signed right now.
All right, Mr. Bennett, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Sir.
Okay.
Here's the terms. So on the 2 new cases. If that's what you'd like to do, sign right here for me, please. Yes, sir. And today's date, please, September 26th. All right, thank you very much. Yeah, don't worry about it. If I may approach, Your Honor.
All right, Mr. Bennett, in 22 CF 1884, you want to admit that you violated probation. And then in 24 CF 1111 and 24 CF 1112, enter a no contest plea to those charges, correct?
Yes, Your Honor.
Okay. And in the 24 CF 1111, it's 1 count of possession of controlled substance, a third-degree felony, fentanyl, a petty theft, second-degree misdemeanor, and trespass after warning, a first-degree misdemeanor. And in 24 CF 1112 is possession of controlled substance, oxycodone, a third-degree felony, and also count 2, possession of controlled substance, meth. So you want to enter no contest to those charges and admit you violated probation?
Yes, Your Honor.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea and admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission
No, sir.
and this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission and plea is freely and voluntarily entered. Court accepts it. Again, 22 CF 1884. Court's going to revoke and terminate probation, sentence you to a new term of 2 years probation, enter a complete Phoenix House rehabilitation program. Bars to bed, comply with Phoenix House policies, $100 VOP fee, $150 PD fee. And 24 CF 1111 and 24 CF 1112. You're sentenced 2 years probation concurrent with each other, and 22 CF 1884, enter a complete Phoenix House rehab program, bars to bed, comply with Phoenix House policies, $100 cost of prosecution, $515 court costs, $100 PD fee on each case, totaling $200 cost of prosecution, $1,030 court costs, and $200 PD fee. On the misdemeanors, you're sentenced to time served. Everything is concurrent with each other and credit for time served. So the misdemeanors are just on each of the cases is time served. Okay?
Thank you, Judge.
Thank you.
So meet with probation.
He is adjudicated guilty on everything.
Thank you, Judge. Your Honor, Tim Gibbs on behalf of Ms. Naomi Cantrell. Judge, this is case number 24 CF 525. She had received a new offer from the state. She is at this time declining it. We had also sent some counter offers that were declined by the state as well. I have not filed a motion, but I did want to ask the court to reinstate her bond. She's currently in on a failure to appear. She's been in for a few months now, for 4 months, I believe. But that's up to the court if the court would entertain that motion, since it's Ori tennis.
What's the state say?
Judge, we'd request notice, and we'd also note that there hasn't been any substantial change in circumstances. Court denied previous bond hearing.
She was out on bond and then she failed to appear.
She was out on bond previously. She ended up, a warrant, a capias was issued for a failure to appear. She was arrested on that. We were asking to reinstate her bond following that failure to appear. She has a dependency case that has now switched from reunification to adoption due to her incarceration. She wants to try to get out so she can see her children, work that dependency case, and try to reunify herself with her children, with her child.
She was in an inpatient program, received an FTA, and she was picked up in Decatur, Alabama, far away from where the inpatient program was in Florida. So we would object to reinstate.
She was in our inpatient program and then took off,
Yes.
allegedly?
Yes.
Deny the bond.
Understood.
Thank you.
Otherwise, Judge, for housekeeping, I think we need to leave her on pretrial.
All right, 8/20, October 28th.
Thank you, Judge.
Next to be Courtney
That's
Curry.
what they're
That
at.
was the
That's
one
what
this
they're at.
afternoon that we moved up for a plea. That's all over the place. Ms. Curry.
Your Honor, I have Ms. Courtney Curry. Judge, this is 24 CF 1965.
Is this a Judge Brown case?
This is on your 130 arraignment.
Judge, we have reached an agreement on Ms. Curry's case. I'm working on getting a written plea now, but I can announce the terms if the court would like.
Is she going to enter a plea today?
Yes, Your Honor.
Sentence today?
Yes, Your Honor.
Is she on the docket?
She is on the afternoon docket. We had her move forward this morning.
What's her name? Courtney?
Courtney Curry, Judge.
Ms. Curry, would you please raise your right hand to be sworn?
Raise your right hand. If you'd like, if you want to plea, go ahead and raise your right hand. If you would like to plea, raise your right hand.
Judge, this is gonna end up to, it's gonna be there's gonna be restitution involved. I think we need to reduce it down to writing. Because
I have it, I'm getting it printed.
I just
I have her names. We can pass her, we'll pass her.
Pass her to a little bit later.
Well, we have it here, sorry.
Oh, you got it?
So, 1,000 to this lady, 500 to him. 2 years probation there, 1 year concurrent because it's a misdemeanor. That's what you'd like to do?
I'll just go to the probation office when I get out.
Yes, we'll meet with probation this morning, but if this is what you'd like to do, to waive your rights and enter the plea, sign right there for me.
How many more inmates we got?
I'm about halfway through mine, I think. Today's date, please. Sign that one.
We're gonna take a break after this case. Crash.
I may approach, Your Honor.
You didn't like that hair color, so you cut it all out? Is that what's going on there?
It was long overdue for a haircut, Judge.
All right, this is 24 CF 1965, State of Florida versus Courtney Curry. Ms. Curry, would you please raise your right hand to be sworn? Did I swear her in already?
I believe, are you having trouble hearing?
Yes.
All right, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, sir.
Okay. You want to enter a no contest plea to the charge of criminal mischief, a third-degree felony, and criminal mischief, a first-degree misdemeanor, correct? You do?
Answer out loud. Would you like to hear that?
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea? You aware of your rights you're waiving?
Are you aware of the rights that you're waiving, the right to go to a trial?
Yes.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
Has anyone forced or threatened you to enter?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1, sentence 2 years probation, $100 cost prosecution, $415 court costs, $150 PD fee, $1,000 restitution to Lauren Patterson. Count 2, 1 year probation concurrent costs, $500 restitution to Barry Peterson. And she is withheld adjudication both counts.
Thank you, Judge.
Okay?
Yes, sir. Thank you.
Thank you.
Just need a probation.
Your Honor, we request you to give them the full 2 years in which to pay the court
Yeah.
on this man.
Okay.
Thank you, Judge.
We'll take a 23-minute break.
All right, please.